I just looked at the probable cause affidavit, which is one of the more disturbing probable cause affidavits this court has had to review in 20 years as a judge. Are y'all ready for a hearing on this? Stay ready to go?
Yes, sir.
Because I more than just casually interested here on, there is video evidence showing the victim appearing in video messages, injured, asking and begging individuals for money, stating she had been kidnapped. Responded, let's see. They found that the defendant and others, the victim had severe injuries, transferred, due to the severity of the injury, she was transported to Houston for special treatment. Suspects tied her up, beat her with a firearm throughout the day, forced her to record and send video messages to her family and friends demanding money, threatening to kill her if payment was not made. A search of the associated apartment revealed evidence consistent with the victim's account, including items indicative of restraint and assault.
Right.
Suspects were transported to the Beaumont Police Department. They were interviewed by detectives. Following their interviews, the suspects were transported and booked in the Jefferson County town. Were there confessions made by anybody?
Not that I'm aware of, Judge.
All right, go ahead, state. What is the $500,000?
We're asking the court to consider $100,000, Judge. I don't think she has much, if any, criminal record. I'm the second or third attorney that was appointed to her.
Why? What's going on? Are they appointed attorneys?
I believe there was a first court appearance sometime in July.
Well, trial, July 5th.
Yeah,
Is that for trial?
yeah. We'll be ready for it, Judge, if called.
Okay.
But we would ask.
I would like the state to be ready on
Yes,
this
sir.
one.
Yes, sir.
We'll make that one specially set for July. Go ahead.
We asked the court to consider, she has ties to the community. She has family. She has a place to stay if GPS and home monitoring or home confinement. Family-wise, kids, and how old are they?
8-year-old daughter.
And who's taking care of the child now?
I have there.
And she needs help, does she not?
Yes, sir.
We would ask you to consider reducing it to.
Okay. I see a probable cause out of there. Is there anything the state wishes to introduce to help the court on the circumstances of this case? I see the probable cause, which is, like I say, a most disturbing rendition.
And that pretty much summarizes, other than the injuries, which, Judge, since this was set this morning on the announcement docket, I don't show a motion that I had for a bond hearing, but that's okay. We'd stand by. The co-defendants are all set at $500,000. We think this is a fair bond due to the circumstances. We don't get kidnappings or ransom where they're demanding money. It's like very rare in this county. I don't know that I've actually defended one or prosecuted one, and since I've been here in '89, the way they were transporting her around and trying to hide her and trying to get money from people, I would ask the court to keep the bond at $500,000. The only reason I'm not saying raise it is because I didn't file a motion to raise it, because I don't know that any bond is sufficient for what she did. As far as having children, she had an 8-year-old, so she had a child when she was doing this. It's not like she didn't know she had a child to take care of and needed to do some parenting at home instead of running around with this group.
Anything else to add? The court's looking at the four corners of this. I'd like to. The court is interested in seeing some more tangible evidence to support what's in this probable cause affidavit, because it's a most serious thing. In fact, I don't think $500,000 may be enough in what I'm reading. I mean, this is a most disturbing set of facts in this probable cause, but I'd like to see something other than the four corners of the probable cause affidavit. Can we have a hearing on Wednesday?
Yes, sir.
Thanks. That's what I'll do. All right, we now call two cases. Clause numbers 21-36529 and 21-36760. The state of Texas, is it Averiana?
It's,
Beverly. A lot of syllables in that. And you were charged with burglary of a building and theft. And in each of these cases, well, you're on probation on each of these, right? And so we have first amended motions to revoke probation that have been filed in each of these cases. The defendant pleaded true last month to allegation 1 and allegation 2 in each case of the first amended motions to revoke probation. That is committing the offense of unlawful carrying of a possession, carrying a weapon, also carrying of a weapon on or about August 5th of last year, and also on that date committing the offense of illegal possession of a controlled substance on or about August 5th, 2025. Each of those are violations of probation. What? I'm trying to read probable cause, David, which is unreasonable, unreadable. It's unreadable. The one is related to this August 5th incident. And the controlled substance, I can't, what is this?
Is that a better copy?
What is the drug? I can't.
There were several. There was
1, 2, 3, 4, 5 drugs.
yes.
Let's see, oxycodone in here. Marijuana. Methazine.
Yeah, I think the one you were looking at was the December of 2025. That's the one I told reading.
No, I got August 5th,
Well, that's one I just gave it.
which is what we're talking
Yes,
about.
sir.
But wasn't there? And what drug was not present? All right, earlier the defendant entered pleas of true to two first amended motions to revoke probation. The defendant is looking at a state jail felony punished as though it were a third-degree felony, correct?
No.
No, it's
Just
state jail.
It's just state jail. We got a cap for 1 year
Okay. Fantastic.
or 12 months. But I need them.
Okay. We're going to state first and last.
Judge, I think I'll be looking at her history and looking at the updated pre-sentence report. We've done everything we can to try to get her on the right track, and she just keeps committing crimes. So we'd ask for the 1 year state jail.
Go ahead. State and defense.
Your Honor, as you look at Miss Beverly, she's a young lady, probably has some growing up to do, especially from her response to the probation department. In reference not seeing the big picture on this. The only saving grace on this, Judge, is
Right.
that if she goes to the state jail, maybe she'll see the light of day and be able to get help in the state jail. Safety would be an option for her when she's incarcerated. When she gets there and then sees the environment and people there, she may have a change of heart. It is my understanding that probation has offered everything that they can to her, but she wants to, but doesn't want to take advantage of it.
Let me ask you, how much is still remaining on restitution? If any. There was $6,000 originally.
Actually, between the two cases, I think it was 8,500.
full balances, but
Sir? It hasn't, none of it has been paid?
yes,
So you got 6,000 in one case and then 2,500 in the other.
Yes.
Judge, she keeps committing other
I
crimes.
know.
It's not like she's paying off the restitution. What am I supposed to do? Just say, well, do it.
I'm asking you.
I understand.
That factor in. She's got 121 days, correct?
Yes, sir.
What do you have to say, if anything?
Yeah.
Nothing?
I do have,
I'm sorry, I can't.
I do have something to say.
I can't hear you, sweetheart.
Speak up. I did make payments in my restitution.
Did you?
And
That's not what we're showing, though. Your probation would know. I'm not seeing any, but
in the other,
has he paid? She's not paid any on restitution in these two cases?
Looks like none of it has went towards restitution.
None of it. I guess you're paying fees or something. It goes there, but it's not going to restitution.
it's doing the best I could to pay the restitution.
Ma'am,
I was doing the best I could to pay the restitution.
from probation, anything you want to add?
No, sir, with the 13 new alleged offenses, it's revocation. It's the best thing I would say.
Yeah. 13 new. Mhm. If nothing further, I'm going to find that there is sufficient evidence supporting these first amended motions to revoke probation. Well, first of all, the pre-sentence reports are made a part of the record in each of these two cases without objection. And in each of these first amended motions to revoke unadjudicated probation, the defendant has pleaded guilty or proved allegations 1 and 2 voluntarily, knowingly, intelligently, and based upon discussions with her attorney. And that is enough to grant these first amended motions to revoke unadjudicated probation by preponderance of the evidence or greater, as I find allegations 1 and 2 in each of these cases to be true. Thus, your deferred or unadjudicated probations in each of these cases are hereby revoked. Earlier in these cases, you pleaded guilty to each of these state jail felonies voluntarily. When I placed you on probation, you were mentally confident to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these two cases. And you were hereby sentenced. The cap was 1 year, I believe, in the agreement. You were hereby sentenced to a confinement in the state jail for a term of 1 year. You will be given credit for time you have served, which looks like it's about 4 months. Also, the judgments in each of these cases shall reflect that restitution in the amount of $6,000 is part of the judgment in 21-36529, and $2,500 restitution will be part of the judgment in 21-367602 to be paid to the complainants in each of those two cases. They are named in the indictment in each of these cases. Anything else?
No.
Thank you so much.
Everything's good.
Yeah.